We'll give a test. Test 1, 2, 3.
4, 5, 6.
Okay, there we go. Okay, so we're going to get started here. I see a few people on Zoom, so hopefully the audio is coming through. Good afternoon, everyone. If you haven't already, take part in the Chipotle. We're going to eat as we discuss here. Welcome to UC Law SS Federal Society's first event of our spring semester. We're very excited to have a very nice kickoff event and speaker. I'm Alexander Del Curto, a 3L and a co-president of the Federal Society here on campus. And I'm honored to be joined by Nadine Strossen. She is the John Marshall Harlan Professor Emerita at New York Law School and past national president of the American Civil Liberties Union from 1991 to 2008. She is a senior fellow with FIRE, the Foundation for Individual Rights and Education, and a leading expert and frequent speaker and media commentator on constitutional law and civil liberties. She has testified before Congress on multiple occasions. She serves on the advisory boards of the ACLU, Academic Freedom Alliance, and Heterodox Academy. The National Law Journal has named Strossen one of America's 100 most influential lawyers, and several other publications have named her one of the country's most influential women. And she's received many honorary degrees and awards. When Strossen stepped down as the ACLU president, 3 ideologically diverse Supreme Court justices participated in her farewell tribute luncheon, Justice Ginsburg, Scalia, and Souter. She is the author of Hate, Why We Should Resist It with Free Speech, Not Censorship, 2018, and Free Speech, What Everyone Needs to Know, forthcoming this year. She is also the host and project consultant for Free to Speak, which is the working title of a 3-hour documentary film series on free speech, scheduled for release this fall. So with that, please join me in giving a warm welcome to Nadine Strossen.
Thank you so much, DC. You agreed I could call you by your
Yes.
nickname, and you're going to call me by my first name. I'm absolutely delighted to be here and so glad, especially having read about my colleague Ilya Shapiro being disrupted when he tried to speak for your organization. Seems like there's no disruption, so that's progress.
Yes. So the title of this event, as was advertised on the flyer, is the State of Free Speech in 2023. But I would like to set the stage for the discussion and conversation by referring back to July 7th, 2020, which was the date of the letter on justice and open debate for Harper's Magazine. For those of you unfamiliar, this was an open letter criticizing what it called illiberalism spreading throughout society. It was signed by 153 individuals from very diverse backgrounds and political equations. There, Wynton Marsalis, the famous jazz trumpet player, signed it. Salman Rushdie, New York Times columnist David Brooks, second wave feminist icon Gloria Steinem, and many others. So you also signed the letter, and I'd like to start by asking you first why you signed it and what you were hoping to get across to the readers about our present moment.
So this was, I think, the first public protest against a term that has now been bandied about and debated a lot, namely cancel culture. And believe me, I, of course, defend everybody's free speech right to criticize anything, to criticize any idea or any person. I defend the free speech right to advocate that somebody be fired or treated punitively in some other way. But the point of the letter is that if we care about having a robust free speech culture in reality, not just as a matter of abstract law, it is not healthy to have disproportionately harsh retribution against people for voicing unpopular views. And I took advantage of the fact that I have this incredibly secure position as a tenured faculty member. The point of tenure is to enable and to facilitate fearless debate and expression of ideas, regardless of how popular or unpopular they are. So it doesn't take courage for me to stick my neck out. That said, I have to say it is very dispiriting how many tenured professors are refusing to stand up for unpopular ideas. But the main reason why I thought it was really important to explain the dangers of calling for harsh retribution is my concern for people who don't have the job security that I have, in particular my students and students all over the country, which public opinion surveys continue to show are engaging in massive self-censorship, refusing to not only to express certain ideas, but even to discuss certain whole subjects. And then when you talk to faculty members, unfortunately, it's a shrinking number of us that even are on the tenure track, let alone have tenure, as universities are loading up on adjunct professors and people who have no job security. So I was basically speaking up in the hope of making it less difficult for students and those who lack the protections of tenure to fearlessly express their ideas. You know, not to be free from criticism and disagreement, of course not, but to be free from worrying about, am I not going to get a job? Am I going to get kicked out of school? And those, unfortunately, are realistic fears.
Well, thank you for that. And I want to pick up with a couple things that you said. So you mentioned cancel culture, and that's a topic that a lot of ink has been spilled, and the commentary ranges from it doesn't exist, it's all in your head, all the way to it's the greatest threat facing civil society. And one of the common responses is, and you touched on this, is it's just a mechanism for accountability. And a lot of the high profile cancellations, these individuals end up with better positions after they're canceled. So how does that fit into the relationship between cancel culture and
even as a factual matter, I kind of dispute that, DC. So one example that occurs to me is former Princeton classics professor Joshua Katz, and a lot has been written about the factual background here, but many of us believe that it was completely pretextual dragging up of a alleged sexual harassment claim that had previously been litigated to punish him for having been critical of certain demands that were made by Princeton faculty and students in 2020, including the creation of a committee that would have student members as well as faculty members who would review all research and publications by faculty members to look for alleged racism or other kinds of discrimination. And he courageously, it shouldn't have to take courage for a tenured professor to do this, but his case proves that even tenure is no protection against the mob if you say something that is politically controversial on your campus. And he landed on his feet in the sense that he's working for a think tank, but for somebody who had spent his entire career at Princeton, absolutely beloved classics professor, devoted and accomplished scholar, I hate to say it for the rest of you who don't think of academia as the best job in the world, but it was his home. It was his home institution. So it could have been worse, but even somebody with that degree of stature and accomplishment suffered a great deal. Now, let me give you, getting beyond the generalizations, one of the really important contributions that FIRE has made, and they changed their name last spring, so it's now to reflect a broader mission going beyond campus, just as the censorial pressures that started on campus have migrated out into the larger society as students have grown up and taken some of their illiberal views with them. Fire decided that it had to expand its original mission, which was the Foundation for Individual Rights and Education, is now the Foundation for Individual Rights and Expression. And it's enforcing free speech rights in many other contexts. But one of the projects that Fire undertook starting a couple years ago is to amass a very detailed database of every instance on campus where they're starting with faculty members, then they will go to students. But so far, of every faculty member who has been the subject of attempted punishment for engaging in constitutionally protected speech. And the numbers are just shocking. I think, approaching 1,000 now, and dozens of tenured professors have actually lost their jobs over constitutionally protected expression since 2015. As the analysis points out, this is far more than higher than the number of professors who lost their jobs during the so-called witch hunts of the McCarthy period during the Cold War. What's also not so well known is how many of these attacks are coming from the right of the faculty member. I think it's well publicized that a lot of attacks on campus are coming from the left of the faculty member, including progressives who are attacking liberals or moderates for not being sufficiently to the left. But a lot of them in some campuses are coming from the right. And Greg Lupiano, who's the CEO of Fire, wrote an essay when these numbers first were published, in which he said there are problems on both ends of the political spectrum on these issues. On the one hand, conservatives complain about cancel culture without acknowledging that they too engage in it. On the other hand, liberals deny that cancel culture exists, even though they too are subject to it. So my message, I know the Federalist Society is a group of conservatives and libertarians. The ACLU, for better or worse, strives to be a nonpartisan organization. I believe very, very strongly that we cannot have meaningful free speech unless we vigorously defend it for all ideas all across the political spectrum. And I know Professor Hand here has been, some of others of you have been active in Heterodox Academy. It's also a nonpartisan organization, as is the Academic Freedom Alliance, all of National Coalition Against Censorship, all of these organizations that are committed to the classic liberal values of free speech, open discourse, academic freedom, understand that we are never going to have freedom of speech for me unless we also have it for thee. Whereas in most people, it's exactly the opposite. They only want free speech for me, but not for thee.
Thank you. And so I'd like to now move on to some of these specific campus incidents that you just mentioned, and then as well in your introduction, you mentioned Mr. Elias Shapiro. This you can call it a trend of not allowing speakers to speak on campus, or what's called deplatforming. And two events are our event last year, with Mr. Shapiro, and then what happened a week later, which was the Yale event. And a common response from students is that these shout downs or hecklers' vetoes are an exercise of speech rights and not censorship. So are they correct with that?
Con Law 101, or if I'm not sure if you study free speech in your basic con law course, but of course there is a really important free speech right to engage in protest, including vigorous protest. But there is a conceptual line between non-disruptive protest, which allows the event to go forward, and disruptive protest, which shuts down the event from going forward. And another basic free speech point that is not nearly as well known as it should be is, much as we might care about Ilya Shapiro's right to speak, or the right of the two speakers at Yale Law School to speak, the First Amendment and free speech principles also protect the right of the audience to hear, to receive information and ideas. So when an event is subject to not peaceful, non-interfering protest, but protest that ends the event, it is violating the rights of speaker and audience members alike. You use the term heckler's veto, DC, and this gets to the history of the free speech principles at stake, which, like most of the robust free speech principles that are enshrined in our law today, resulted from the civil rights movement of the mid-20th century, because all of the strategies that are now being used on campuses, often by students who are supportive of civil rights and human rights, are exactly the same tactics that were used by the anti-civil rights government officials and citizens during the civil rights movement to stop Martin Luther King and others from advocating for civil rights. We just celebrated Martin Luther King's day, his birthday, and most people know that he wrote a famous letter from the Birmingham jail. I suspect most people don't know why he was in jail. What was the crime that he had committed or allegedly committed? And it was nothing more nor less than trying to exercise what we now consider to be fundamental First Amendment rights, but not then. And no coincidence, the Warren Court became a great protector of free speech rights, First Amendment rights, at the very same time that it became a great protector of equal rights. And so many of the great cases that have guaranteed freedom of speech for all of us were hard won through the efforts to suppress civil rights demonstrators. So wonderful professor at the University of Chicago Law School, Harry Kelvin, a great expert on the First Amendment. He actually wrote a whole book called, and please forgive me, it's not considered a polite term now, but then it was the polite term. The book was called The Negro and the First Amendment. And he basically said that the Supreme Court, in its zeal to foster the flourishing of the civil rights movement, was protecting free speech rights that it had on behalf of civil rights activists that it had refused to protect on behalf of accused communists just a decade earlier. So the tactic, he coined the term heckler's veto for a tactic that was used throughout the South. You would have completely peaceful, often students, college students, law students, high school students, demonstrating together with ministers and others who were members of the civil rights movement, simply against Jim Crow laws, simply for basic legal equality, the right to vote, the right to use public accommodations. And because their opponents, who thought that this was just so dangerous to their way of life, and so they actually use terms like that we hear bandied about today in a very different factual context, that this pro-civil rights speech was denounced as dangerous, as subversive, as treasonous, as emotionally traumatizing, defamatory, violent. Here we often hear students today say speech is violence. I mean, you go back and you read some of these old Supreme Court decisions, and it's amazing. Cases from South Carolina and Louisiana. The one from South Carolina, the state Supreme Court actually upheld a breach of the peace conviction for a group of students who were singing Black and White Together. I get chills as I say this, because the state Supreme Court said that expression, that phrase, that idea is inherently violent. Of course, this constitutes a breach of the peace. So I could go on and on, but because of the threatened, ironically, the threatened and actual violence came from the bystanders who were objecting to these messages, that was allowed to shut down, i.e. to veto the speakers and the demonstrators. So I think, you know, that historical origin really underscores that if you want to have freedom for ideas that you cherish, including anti-discriminatory ideas, you need to protect and enforce the same principles, even for in a very different factual context.
So you mentioned there the common argument about you know, speech being violence, and I'd like to kind of proceed with that line of discussion. So we at the Federal Society here, our chapter have a best practice of specifically seeking out events and organizations that represent ideas that we think we disagree with, or you think you disagree with. And through this practice, we've encountered some really sincere arguments and assertions kind of against the free expression, certain kinds of expression on campus. So I'd like to just go through them. You mentioned the speech and violence one, but semi-related to that is the idea that free speech rests on a faulty notion that words are harmless. And I think, you know, everyone here can attest that the most hurtful things don't normally come from the end of someone's fist or from the words that they uttered. So how would you respond to that assertion?
Yeah, a lot of the attacks on free speech come from a completely distorted, caricatured version of what free speech principles are and what free speech advocates, including on the Supreme Court, have actually asserted. I can't tell you how many times I've been told that, you know, oh, you Strossen, you're a free speech absolutist, and you don't acknowledge that speech can ever do any harm. And the answer to that is no, for me, and even far more importantly for the US Supreme Court. In fact, in one of the court's recent, let me make one general observation about the court, and then I'll dive back into this particular aspect of their strong free speech protective jurisprudence. We all know how deeply divided the Supreme Court is now, that there are dissenting opinions on most constitutional law issues. However, what is really striking is that when you look at the free speech cases, with some exceptions, the court is by and large unanimous, with at least very strong consensuses, you know, like 8-1, if not 9-0, on cases involving the most controversial speech, where the general public is deeply divided. So the court has recently had cases about hate speech and, you know, other extremist speech and other kinds of controversial speech, where, you know, from very few exceptions, from the most liberal to the most conservative justice, they are still upholding the free speech rights. And I think one of the reasons for that is that they are aware of what the actual legal principles are, as opposed to this distorted, caricatured version that floats about in the public. And they're also aware of the history, including the history of the civil rights movement that gave rise to those speech protective principles. So I actually think information and education about free speech really translates into advocacy in favor of it. So one of these recent cases where the court strongly protected hate speech, extremely controversial speech, was Snyder versus Phelps. I could put on my law professor hat and ask somebody to state the facts and the holding of the case. But that was the one involving so-called Westboro Baptist Church. And please forgive me, I'm going to quote its website and its motto, even though it uses an ugly term, www.godhatesfags.org. But this church basically believed that God hated just about everybody other than members of their church. So they engaged in expression that was very disparaging, not only of LGBTQ people, also of Catholics, of members of the military, among others. And there was an attempt to hold them culpable for the emotional distress that they had caused to the father of a slain member of the military when they demonstrated outside his funeral. The Supreme Court very strongly rejected that claim, arguing that on the rationale that when you're addressing matters of public concern, because this had to do with policies of the military, policies of civil rights laws. So it was a matter of public concern in a traditional public forum, namely on a public street and sidewalk, that we could not allow speech to be suppressed solely because of the psychological or emotional harm. And the Supreme Court went out of its way to acknowledge that the plaintiff in the lawsuit, the father of the killed member of the military, the killed Marine, had suffered psychological injury. The court did not at all minimize it and said, look, the reason we protect free speech is precisely because it is so powerful, a power that can do a great deal of harm as well as a great deal of good.
Thank you. And I guess the second one, in addition to the harm argument, is that free speech rests on the false premise that the marketplace of ideas will eventually lead to the truth. ACLU lawyer Emerson Sykes, whom I respect very much, visited our campus, and a lot of the people in the audience attended his talk. And that was one of the things that we spoke about. And I want to get his quote. He made the argument saying that, quote, unfettered speech will eventually and inevitably lead to truth and justice. This kind of argument has outlasted its utility. So how would you respond to that?
Nobody ever made that argument. And I too really respect and like Emerson, whom I consider a friend as well as a colleague. But as with some of my most cherished friends, dare I say, even my beloved husband, I don't agree 100% of the time. And Emerson and I have had this disagreement in person as well. I'm not aware of anybody who has ever made the clearly frivolous argument that truth is necessarily going to triumph in the marketplace of ideas. And if you look back to the origin of that statement in a famous dissent by Oliver Wendell Holmes early in the 20th century, he never made that claim either. His exact language was something like, a better test of truth than centralized control is through the marketplace of ideas. But he qualified that immediately, and he said, this is an experiment, as all life is an experiment. And he used, very qualifying language. We may find, and the answer is that, or I think the correct question is not, is truth necessarily going to follow from freedom of speech, but is truth more likely to follow from freedom of speech than it is from censorship? And while the free marketplace of ideas may well not lead to truth, I think censorship is guaranteed to determine that truth will not prevail. Let me also quote another ACLU lawyer, also from this part of the country, Melville Nimmer, who wrote a famous case book, I think, on intellectual property rights. And Nimmer said, if we don't allow the marketplace of ideas to be the selecting factor, what is the alternative? Are we going to allow either a minority of the community to make those determinations, we going to allow a centralized authority? So I think it's kind of, I keep thinking of Winston Churchill's famous aphorism about democracy being the worst form of government except for all of the others. You know, I think the marketplace of ideas is pretty dangerous, but less dangerous than the alternative. In addition to that, there are a number of independent rationales for free speech, including that its essential role in promoting tolerance, its essential role in promoting human rights, its essential role in promoting democracy in the sense of, you know, a democratic republic, where speech is especially important for we the people to effectively wield our sovereign power, and also as a matter of individual self-expression.
So the last one I wanted to kind of hit is the idea that free speech is a tool of the powerful and not the powerless. So in the beginning of your remarks, you talked about you know, kind of address that in a broader sense. But I was wondering if you can address it more, given the theme of this talk, kind of the campus speech issue, and that having that speech is not for the powerless.
You know, along with every provision in the Bill of Rights, it is, and here's a term that those of you who have taken common law may have encountered, it is deliberately and decidedly counter-majoritarian, right? That in our democratic republic, we the people, to quote the opening words of the Constitution, wield sovereign political power. Therefore, the majority through elected representatives can make most public policy decisions, except there are certain rights that are deemed to be so fundamental that no majority can take them away from any minority, no matter how small or unpopular or even despised that minority might be. And that was precisely the purpose of the Bill of Rights, including the First Amendment with its free speech guarantee. You know, people were always asking me when I was head of the ACLU, why are you defending free speech for, you know, right-wing extremists and, you know, pornographers and others who are engaging in controversial, unpopular expression? And the answer is, first of all, we're not defending what they say. We are defending a principle, and that redounds to the benefit of everybody. And the principle is rarely challenged when what the person is saying is popular and beloved, then you are not likely to be subject to censorship. And if you look at just look at a common law case book with First Amendment cases, you will see case after case that's brought by the Jehovah's Witnesses or members of the Communist Party or members of the Socialist Party, and, you know, all across the political spectrum, members of the Ku Klux Klan, but not members of the mainstream who are wielding political majoritarian power. And you look at the history of movements for social justice and equal justice in this country, and you see that they have, you know, tried to get off the ground even, you know, before the 20th century, and never really came to fruition until the Supreme Court strongly enforced freedom of speech for the first time in the middle of the 20th century. So who were the people why was the ACLU founded more than 100 years ago? Because the people whose speech, and we would hopefully come to the defense of, and have come to the defense of anybody, but at that time, it was the World War I era, and 15,000 people were imprisoned merely for peacefully expressing opposition to the war. You know, that people who were agitating for labor rights, women who were advocating for suffrage, people who were advocating for contraception, reproductive freedom, anybody on the left end of the political spectrum, those who were advocating for racial justice, I mean, were all suppressed because their ideas were unpopular and because they lacked political power. So freedom of speech is especially important for those who lack political power.
So before asking my last question and moving to audience Q&A, I'd like to address some solutions. And in chapter 8 of your 2018 book, Hate, Why We Should Resist It with Free Speech, Not Censorship, published by Oxford University Press, you list non-censorial methods which effectively curb the potential harms of a constitutionally protected hate speech. So what are some of these methods, and are they applicable to law school campuses?
I'm not sure about the second part of the question, DC, but let me start with, the open-ended part of it. The title of my 2018 book, and thank you for mentioning it, is Hate. Why? So the main title is Hate, and then the subtitle is Why We Should Resist It with Free Speech, Not Censorship. Note that the only verb in that title is resist. My mission is to resist hatred and discrimination and stereotyping of every sort. And I continue to be convinced that no matter how well intended censorship that goes beyond what is permitted under First Amendment principles does more harm than good. And it's less important for me to quote myself. Book quotes human rights activists from around the world, including many countries that allow the suppression of hate speech. There's no constitutional problem in those countries because they don't have the same understanding of free speech that we do with respect to hate speech, but specifically from the perspective of, is it an effective way to reduce hatred? You have these human rights activists at the national and international levels around the world saying no. And when you think about it logically, if you're trying to eradicate or change an attitude, you're trying to change behavior, and zeroing in on expression does neither one of those. You're never going to effectively change somebody's mind by imprisoning them, as happens in other countries, or in this country. I would say, one of the reasons why I oppose overly harsh shaming and shunning and cancellation is it's not an effective way to change somebody's mind. Education and persuasion are much more laborious paths, but they are really the only ones, I think, that are likely to change hearts and minds and behavior. And, I try to the best of my human ability to be open-minded. If I saw evidence that increasing government power to restrict hate speech beyond what it already has in our system would be effective and necessary, and now you'll recognize some constitutional language here, the least restrictive alternative to further equality and non-discrimination, I would be all in favor of it. But I have not come across that evidence to the contrary. But on the positive side, I have been so encouraged about education and constructive interventions, including, since I mentioned the Westboro Baptist Church, it's just one of a number of instances recently of former leaders of hate-monger organizations who have repented the error of their ways and dedicating the rest of their lives to trying to repair some of the damage they've done. I'm referring to Megan Phelps Roper, who was born into this church from the time she was a child, lived in isolation with her family, and was taken out on these protests, waving the ugly signs. And she went onto Twitter in order to recruit people to her church, and instead, as a result of very patient discussion on the part of a rabbi in Israel, of all people, who just engaged with her in a respectful, compassionate way, not compassionate toward her ideas, but toward her as a person, started discussing with her the Bible verses that their whole religious philosophy was based on. And she gradually came to question those interpretations herself, ultimately left the church, which meant leaving her whole family. It really took, courage in the sense that she thought everybody out there would hate her. And she wrote a memoir about this called Unfollowing, Loving and Leaving the Westboro Baptist Church. And there are many other examples. There's a whole organization based in Chicago called Life After Hate that consists of people who even were leaders of white supremacist organizations. And there's a common theme, they give TED Talks and they write books, and they say that a punitive approach would never have worked. But reaching out to them with understanding and respect and patience is something that is likely to, it's not guaranteed to succeed again, but I think censorship is guaranteed to fail.
So for my last question, I want to circle back to a theme that we kind of started with and ran through our whole conversation, namely the idea that, this topic, free speech, is not a conservative or a liberal talking point. And I mentioned it in the introduction that you sit on a few advisory boards, FIRE that you mentioned, and the Heterodox Academy. So I was wondering, for those that are unfamiliar with these organizations, if you could just speak a little bit about them and how specifically their consistent advocacy, regardless of political persuasion.
Yeah, and I would say that for the ACLU as well. And let me put in a plug for I still say we when I talk about the ACLU. And I may get a question about this, as I did yesterday at Stanford, so let me anticipate it. The ACLU's most famous or infamous case ever, depending on your perspective, is the so-called Skokie case from the late 1970s, when we came to the defense of a group of neo-Nazis demonstrating in Skokie, Illinois, a town that had not only a large Jewish population, but many of them at the time were Holocaust survivors. And that was very controversial within our membership. We lost about 15% of our members, but then quickly regained, including for people who said, gee, you really are neutrally principled, even-handedly defending freedom of speech, even for the thought that you hate, to quote Oliver Wendell Holmes. I don't think as many people know that the ACLU did essentially the same thing just a few years ago when we defended the freedom of speech for the Unite the Right demonstrators in Charlottesville. And came under enormous attack and still coming under enormous attack, including a lot of dissension and candor among ACLU staff members. But so in that same tradition, FIRE defends all the same free speech principles now in the larger public sphere as well as on campus. And I would say the pattern is, and this certainly was the pattern for the ACLU, that the makeup of your clients, the ideological makeup of your clients, pretty much follows the general ideological makeup in that geographical vicinity. So if you're on a conservative campus, where liberal perspectives are more likely to be the ones that are censored, those would be the complainants who would come to the ACLU and FIRE and vice versa in the obverse situation. Heterodox Academy is a really interesting organization because it was founded about 8 years ago. The principal founder, Jonathan Haidt, who is a renowned professor of social psychology who teaches at NYU Business School. And Jonathan, as a distinguished social scientist, was concerned about a number of studies that showed that social scientific research was being damaged in its accuracy and nuance and complexity by the growing lack of heterodoxy in the relevant departments and the relevant discipline. So when your research wasn't subject to review and examination by somebody who had very different perspectives, it wasn't done as rigorously, and there were actual several social scientific reports that document that in a very, very detailed way. So he was not coming at this, nor was heterodox, from the perspective of advocating free speech in the abstract, but much more from advocating and seeking to preserve the university's special truth-seeking mission, the scientific method that is used in the social sciences and other fields as well. And that cannot work unless you have robust freedom of speech and discourse. And that can't work unless you have a multiplicity of perspectives. I think one of the things that's really important to say about Heterodox Academy, and is always stressed by Jonathan and the other leaders, is we are not enemies of traditional universities. I think a lot of politicians like to attack universities and go on crusades against them, kind of an anti-woke movement. Heterodox is not in that camp at all. If you look at its website or any of its materials, it's saying, we love universities. We are doing everything we can to try to help universities live up to their best potential, live up to all those mottos, truth and light and so forth.
Thank you very much for that. So we are now going to move into the audience question portion of the program, and we do not have a portable mic, so just speak up and we will call on you. So let's start with Hannibal and then Sean, and then we'll move on from there.
So is there any solution to tyranny? Is there any solution to tyranny and majority problem, or are we kind of stuck here forever?
Hannibal, that is such an excellent question. And let me say that this is part of the reason why I still enthusiastically support the Harper's letter, because a strong legal protection of free speech is necessary, but not sufficient to bring about what I consider to be a free speech ideal. And I think I haven't said what that is, and maybe it goes without saying, but the free speech ideal is not just the abstract, theoretical, legal right to be free of government punishment, but it is a lived reality where every member of our community feels encouraged and empowered to participate in the exchange of ideas. And that requires education. It requires the availability of resources, including technological resources, psychological resources, especially for those whose voices have traditionally been marginalized, but for discriminatory reasons, but also for those whose voices are marginalized because their perspectives are unpopular. And that requires a so-called free speech culture as opposed to a cancel culture. Bringing about cultural change is a much more difficult project. And it's not something that we lawyers are necessarily empowered to do. And it really has to come from the top down. So I think the kind of leadership that I perceive as an outsider, the excellent statement that your leaders gave in response to the Ilya Shapiro situation, standing up for free speech principles, that's again necessary but not sufficient, because it also has to come from the grassroots up, if you will. When you look at the public opinion surveys, campus after campus, students are saying we don't feel free to express our ideas or even to discuss certain subjects, and faculty members say the same thing. Faculty members actually come off very well in those surveys because students say they don't fear that they're going to be punished by faculty members. That's a minority who fear faculty retribution. They are afraid of their peers. So somehow we have to create some mechanism to embolden students to tolerate and even celebrate diverse perspectives.
So this question has a bit of preamble, but I promise there's a payoff. Two of the topics we discussed today were these ideas that, one, that words can be themselves a form of violence, and second, that the marketplace of ideas does not necessarily lead to truth. My concern over the past couple of years has been that I see these two ideas starting to fuse together. And the concrete example I have of that is the Department of Justice's 2021 Domestic Terror Policy Update, which among other things includes the idea that the propagation of, quote, mis, dis, or malinformation could be considered a form of domestic terrorism vis-a-vis an attack on digital infrastructure. And of note, mis, dis, or malinformation is defined to include information that is objectively true, but nonetheless deemed harmful in some way. So given that, I'm very curious what your thoughts are on that policy, and also more generally, this idea that speech could be used as a sort of, is being reframed as a sort of attack on the state, as it were.
Well, what was your name again, please?
Sean.
Sean, that was excellent, definitely had a payoff. I'm very, very concerned about this, and it's maybe a bit of an aside, but I think whatever else you think about Elon Musk, I personally think that the fact that he released those Twitter files was a real service, because we now have documentation about the extent to which, in the name of protecting national security, we have the national security bureaucracy, the Department of Homeland Security, and the FBI putting an enormous amount of pressure on private sector actors to take down information that's inconsistent with government policies. This, to me, is, very troublesome censorship. And let me be a con law wonk. Those of you who haven't yet taken con law might not know this, that the First Amendment does not give you any protection against speech restrictions by private sector entities such as Twitter or Facebook. But there's an exception to that. There are a couple exceptions. And one that seems to be applicable now, at least worth considering in light of this kind of evidence, is that ostensibly private sector deplatforming and shadow banning decisions are sufficiently entangled with, induced by, coerced by, in collaboration with the government, that it should be seen as being subject to First Amendment restraints. The government should not get to do an end run around its First Amendment obligations by, in effect, delegating censorship to private sector entities. And that's now it's a very fact-intensive inquiry. It's being litigated in many cases, and that's a really, really important general issue. The concept of, malinformation indeed is defined as true information that might have an adverse impact. As is true of hate speech, with respect to false speech, our First Amendment principles draw what I consider to be a sensible line. And that is, government may restrict the speech that is the most dangerous and the most harmful, but it is prohibited from engaging in the censorship that is the most harmful. And let me expound on that just a bit. The censorship that is the most harmful is a censorship where the speech is restricted solely because of disagreement with its viewpoint, its content, its message, or its idea. But conversely, when you get beyond the content of the speech and you look at it in its overall context, the court has said, well, if in all the facts and circumstances, speech with any content, whether it be false information, whether it be hate speech, if in context it poses an emergency, it directly, imminently causes or threatens certain specific serious harm, then it can be censored. There's to be a tight and direct causal connection between the feared harm and the speech, because once you give the government more latitude, as it used to have, before the 1960s under the so-called bad tendency test, speech that might indirectly, perhaps at some future time, lead to harm, that just gives the government essentially unfettered subjective discretion. And that's why we have people like Martin Luther King and others that I recited, anti-war protesters, pro-union advocates, and so forth, being suppressed. So with respect to false information, our law does recognize, consistent with those principles, defamation, perjury, fraud, speech that intentionally is conveying, a verifiably falsifiable or verifiable fact, not a matter of analysis or opinion, that intends to and does cause specific harm, that can be punished. But when you get beyond that to this, mealy-mouthed concept of disinformation, I need not tell you, we've got examples abounding. One person's disinformation, or dare I say fake news, is somebody else's cherished truth. What's considered and consistent with the scientific method, even the very same experts justifiably are re-examining and reconsidering and revising their opinions based on new information, new evidence, new analysis. We saw that throughout the pandemic when, even the very same government agencies were changing their recommendations about matters, including masking and other policies. So not only is it inconsistent with individual liberty to give the government this open-ended authority to suppress so-called disinformation short of these specific categories that cause imminent harm. It also is completely inconsistent with democracy, with public health, with the very values that are said to warrant the suppression.
Would you say that professors should be held to a higher standard for the kind of speech that they utter and the viewpoints that they have? I know that you talked about how viewpoint discrimination should never happen. You cited cases like Skokie and Snyder versus Phelps, but of course, I think that if any professor were to have, neo-Nazi opinions or homophobic opinions, that would be grounds for firing a professor. So where do you draw the line when it comes to professors? Because I know that you talked about how a lot of professors are being fired.
An excellent question and very complicated, because certainly when you are fulfilling a professional role and a professional responsibility, there are appropriate constraints on what you say specifically in that role. So a faculty member who is propounding false information, or for that matter, irrelevant information in class, is subject to professional discipline, including not being hired in the first place or being fired in the second place. But I think, where most of the cases involve another context, and it's a controversial one, and that is what is called extramural speech, that you should not, as a faculty member, have to give up your ordinary free speech rights as a citizen to speak on matters of public concern, let's say in your tweets and your off time, or an op-ed or a commentary on a TV show. There have been many cases where courts have so let me give you an example of, let me make one other point, which is the United States Supreme Court has very little case law on this issue. It's had a lot of very general statements about the importance of academic freedom, but most of the understanding of the detailed protections comes from the American Association of University Professors, the AAUP, and the Supreme Court has expressed support for the AAUP principles. And I'm sorry, I'm not going to remember the exact language, but the concept that the AAUP adopted with respect to extramural speech is that it's protected unless the statement demonstrably shows professional incompetence. And then it has another statement that says, and very rarely will an extramural statement satisfy that burden, especially because you have to consider it against the whole context of the professor's overall record. But I think, a clear example would be if an astronomy professor is writing blog posts saying the Earth is flat, or the Earth circles around the moon, or something that's clearly incorrect. That would demonstrate incompetence. But what usually happens is somebody who's teaching astronomy will issue a blog post about a totally different subject, namely a controversial cultural issue, let's say about, I'm thinking of a very specific example, DEI policies. No matter how unpopular or maybe incorrect those views may seem to be, that should not be ground for dismissing or punishing that person in his or her academic capacity.
So we do not have a hard stop, so if it's all right with you, I'll take a few more questions.
I kind of want to follow up on that last point, because, we see examples of the heckler's veto, some of the really ham-handed, just punitive action by school administration. So that's kind of one basket of issues, and I worry about that. But I also I have a concern kind of moving forward about the way in which facially neutral standards and policies are being applied in a manner that could chill or punish speech. And you just raised one of them, this idea of teaching competence. I've been working on an academic freedom committee here in the last semester. We have faculty that have kind of posited the view that, if faculty are engaged in discussion of issues, particular issues, or discussing them in a particular way, that could be deemed that's not competent teaching. Diversity and equity and inclusion statements for hiring and promotion or another, facially neutral, but depending on who is sort of making a judgment about whether those standards have been met, they could act in a way to chill speech. And we have just so little ideological diversity in the faculty and administration of this school and many schools that the bias of the majority, consciously or unconsciously, gets imported into the application of those policies and principles. So that's a tougher battle to fight.
Yeah,
I wonder if you have thoughts on that.
Keith, an excellent point, and it's illustrating why it is important to have legal standards, which would include the policies of groups like the AAUP or your own academic freedom policy, that constrain discretion as much as possible. It's impossible, nor would we want to completely eliminate it. But the more wiggle room there is, the danger is that it will become an allegedly neutral standard will become a pretext for engaging in what we all agree to be the worst form of censorship, namely viewpoint discrimination, that somebody is being singled out solely because of disagreement with their viewpoint. As to the required DEI statements, organizations that I respect and belong to have come out universally with statements against them. The Academic Freedom Alliance did so. Interestingly enough, that statement was principally authored by Randy Kennedy, who's a professor at Harvard Law School, African-American, clerk for Justice Thurgood Marshall, the first Black Supreme Court Justice. And Randy has devoted his whole life to civil rights, and understands the importance of intellectual freedom and other free speech values as essential for promoting civil rights. It was a very strong statement against that kind of compulsory expression, which I think is not actually content neutral. The Heterodox Academy and FIRE have also come out against those statements. There's something, my longtime ACLU colleague, Matt Coles, who's a distinguished member of your faculty, and I were talking about what to me is a difficult case before the Supreme Court now, the website designer case. And the reason why it's difficult for me is that it involves compelled speech, which I agree with the Supreme Court, along with these statements, presents an even more intrusive violation of individual conscience than stopping you from saying something. When the Supreme Court first addressed the issue of compelled speech, it was, I'm very proud to say, in an ACLU case in 1943, long before the court was protecting free speech in any meaningful way, it struck down compelled flag salutes by members of the Jehovah's Witness church, and they specifically had a religious objection to saluting the flag, but the court went way beyond that and talked about freedom of conscience and thought, and said that it was even more violative of those intrinsic freedoms essential to our humanity to be forced to say something we didn't necessarily believe than to be shut up from saying something we did believe.
So let's go in the back, Professor.
I really think, I love the website you have, by the way, it's very detailed. Thank you. And all the students. You said a few minutes ago, we were going to start with the website, which is how to develop the culture of these people, necessary consultation. And then you said students are more afraid of their peers than anyone else, and not follow the rest of that, the most vigorous line. Can you give us what I think this means? I'm afraid that in class, I raise my hand and I say, I like policy A, and everyone else hates policy A. Most people disagree with me, but I won't invite parties. All this, like that. How can we give us some practical ways to undo that? So maybe that's too heavy a question.
No, it's not.
Professor Blood.
Professor, thank you. Long before, I've always taught my classes in a way that never asked the students for their own views. It seems to me that but require all of them to be able, and here's a mantra, all of my students will recognize it from my syllabi for decades throughout my teaching career, that they are responsible for understanding, articulating, and advocating all plausible perspectives on all issues that we study. And they have to be able to defend not only the majority opinion, but also the dissenting opinion and the concurrences and the partial dissents and concurrences. And with all due respect to my students, I could care less what they actually think, right? I am training them to think and practice like lawyers. And, for me, that was always a pedagogical benefit. But recently, I have come to understand that it has this side benefit of the students don't have to associate themselves with any view that they are being talked about compelled speech, right? And the difference between the standard in the classroom, but general free speech. Now, I understand that at some schools, students are saying, even as devil's advocate, quote unquote, that they refuse to be associated with certain perspectives. That's an even deeper problem. But I think that should go a long way toward liberating them to express those views in class. Outside of class, it's a whole different matter. The University of Chicago is constantly ranked by FIRE as having the most hospitable climate for free speech. But I dissent in the sense that they're clearly only looking at the policies and principles. I have friends who are undergraduates at the University of Chicago who feel as constrained in saying something that might go viral on social media as students everywhere else. And let me mention, one undergraduate at the University of Chicago who worked for New York Times columnist Bret Stephens last summer, and he recruited her to contribute to a journal he edited last fall on cancel culture. He said, you know, we ought to have a piece from a student. And she agonized with me and her mentor, Jeff Stone at the University of Chicago Law School, and Bret, you know, I don't know if I should write this because it could endanger my getting into grad school. It could endanger my getting a Rhodes Scholarship or a job. You know, even the fact that Joshua Katz, this professor, former professor at Princeton, was writing a piece, sort of the guilt by association, who think that he was justly canceled. And she wrote a very powerful piece, which she ultimately published. But the last sentence in it was, you know, and even now I am hesitating to hit send. Now, you know, how do you get beyond that? I completely respect and understand everybody who decides not to take the risk, because it is a real risk. So I would never pontificate. Oh, you know, some people say, oh, just have courage. Oh, please. But what I do really respect are those students who do speak up. And I wonder, you know, I talk to them at every opportunity I have. One is Trent Colbert, who was the Native American leader of the Federalist Society at Yale Law School, who was threatened on videotape that he captured by 2 Yale Law School administrators that they were not going to give him his character and fitness recommendation because this was the so-called trap house incident. And I just marveled at how did this student have whatever it takes to stand up to that kind of administrative pressure. He's an extremely modest guy. And he said, he gave me one piece of advice, which is, he said, you know, like fire and heterodox and ACLU, you got to do a better job of marketing, was the term that he used, because he was so surprised to find that he had these institutional resources backing him up. And he said that would have been very helpful if he had known. But other than that, he pointed to something that accords with social psychological studies I've read, that he said, you have to have it could be a small group, but it has to be some people that you absolutely trust and who absolutely trust you. It doesn't have to be a lot, but it has to be there. And social psychological studies have shown that people have this pressure toward conformity. They'll even deny you know, the evidence of their own eyes and senses. But if there's one other dissenter, you know, who dissents first, then it becomes much easier for others. So that's what we have to encourage, is that kind of, you know, if one person, and that's the idea behind the Academic Freedom Alliance that was founded a couple of years ago, that we're going to band together and we're going to stand up for academic freedom, no matter how much we disagree with what the person said in extramural speech, for example. But it's just they know that they have that somebody has their back. Maybe we could create parallel groups among students, or a campus by campus.
Well, I think that's a great place to end the formal portion of our event. So please, everyone, let's give a warm thank you to Nadine Strossen. And there's still 2 left if you didn't get any.